Today we're going to be looking at the Postal Service, but we're looking specifically at just one section of it here, and that's going to be towards the mail fraud section. So what we want to do is start with, let's see here, the basic, the topic, the scope of this entire AmJur on Postal Service discusses the organization, management, and operation of the Postal Service, the powers and responsibilities of the Postal Service, its officers and employees, fiscal matters relating to the operation of the Postal Service, and its facilities, equipment, and supplies, the mailability and exclusion from the mail of certain items, the classification of mail, the deposit and transmission of mail, the disposition of non-mailable or undeliverable matter, and the various offenses against the postal laws, and the practice and procedure in the prosecution of such offenses. So what we're going to be looking at here mostly is into these fraud elements. Now there's federal aspects. The operation and management of the Postal Service is governed by federal laws and regulations. You got that? So we got Code of Federal Regulations and federal laws that will govern the Postal Service. However, the mail fraud statute, which we will be reviewing today, reaches only those frauds in which the use of the mails plays an integral role. So the mail fraud statute reaches only those frauds in which the use of the mails plays an integral role. All other frauds are dealt with by the appropriate state and federal laws. So it's a very specific mail fraud statute that we'll be looking into that will reach frauds which use the mail when it's an integral part of a role. It's integrated into the role of the fraud. Then this statute will reach that type of crime. If not, then other frauds are dealt with by the appropriate state and federal laws. Okay. Again, there's going to be treated elsewhere a lot of other topics here, but specifically Postal Service is what we're focusing on here. And to get to the mail fraud, let's get right to it. Okay, let's see who's here. Give me just a moment. Let me just check on the chat here. And let's see here. Gosh. All right, there we go. We gotta show that. There we go. All right, before you check out, I can't stay. Catch reruns. All right, Coke Dog. Great to see you here, though. Service of process is integral. Oh, yeah. Postal service. What we're going to do here, though, is a reason I'm doing this, word wizard also, is to get away from any speculation interpretations outside of American jurisprudence. So we're really focusing this context that are going to be directly related into documented and practiced principles of American jurisprudence that apply to postal fraud in specific, but the Postal Service runs through this entire topic. I believe once you start to see some of the things will start popping up that do apply directly to things that Word Wizard speaks about. And if anyone hasn't seen him, he makes quite a few appearances over on the Paul and Slave channel, and he has his own El Perro. And later on, we'll get a link up there for you. So he goes deep into etymology of words. What we're doing here is going deep into the principles of law in American jurisprudence in specific. Now, the mail fraud statutes here are going to be alluding to a lot of the language that you'll hear from Word Wizard, because he's very versed in postal regulations and that Code of Federal Regulations that were previously mentioned. However, when you have to appear or if you have to make any kind of motion towards the courts, referring to these texts here are going to give you some teeth to what you're trying to get the court to move, and also to make your argument a lot more transparent for the people that don't want to interpret it the way it's actually been interpreted by, as we'll see here, judges with far more knowledge and wisdom than most out there today. And we're going to use their interpretations of the very rules and laws that we go through here and principles in common law so that when you present these types of arguments, they will be rock solid, airtight, and will stand as truth and fact. So let's proceed here. Again, I've picked up things from Postal Service in previous AmJur reviews that we've done here on this channel. Specifically, I'll bring to mind one that was under appearances. And when you appear for any matter in the court, just the mere fact that you include your mailing address along with any type of answer to the court, along with your name and a reference to the case, it actually would constitute an appearance before the court. And at that point, it could be jeopardizing any challenges to personal jurisdiction in that matter. So the postal address, believe it or not, has wide-reaching effects throughout common law. Let's continue. So today we're going over mail fraud, matter in furtherance of scheme or artifice to defraud, nature of offense, purpose, and validity of statute generally. So I don't want to pretend like I know every word, and I know we all don't either. So let's go through some of this. We have a great word here called artifice, right? So we could look this one up here. And if you just give me just a moment here, I need to... the very first one always takes a little bit longer, guys. It's a big document here. I need to load up something here so I can just search it a little bit quicker. And we're going to get right to the matter here. And we're going to look up artifice and start with that word. Part of what I like to do on these reviews is to go through every word and, as I say, leave no word behind. And we're looking up artifice. Excellent. 156. So we should be able to get right to that. Okay. Yes, we're going. Beautiful. Okay, an artifice is a clever plan or idea, especially one intended to deceive. Artifice. An artificer is a skilled worker, such as a mechanic or craftsman, an artisan, one who builds or contrives, an inventor. So an artifice is a clever plan or idea that you've invented. Artificial. Extending only by virtue of or in consideration of the law. Wow. Artificial presumption. Existing only by virtue of or in consideration of the law, not of nature. Artificial. This term is often used in reference to a company or a corporation. See artificial person under person, which is a whole nother topic here. Made or produced by a human or human intervention rather than by nature. Artificial condition. Of or relating to artifice. There we go. An artificial demeanor. See how this all comes together. Of or relating to an artifice. An artificial demeanor. Think about this. An artifice is a clever plan or idea, one intended to deceive. And demeanor, intended to deceive. You get that? A clever plan or idea, especially one intended to deceive. So this is how the words work, especially in law. As you see, we're looking at this virtue of or in consideration of the law, only by virtue. So, very good. We got some nice little breakdowns of that word there, and let's get back to our AmJur here. So now we know what this means by artifice. This is a scheme or a clever plan intended to deceive. All right, to defraud the nature of the offense, the purpose, and validity of statute generally. Let's continue. Again, you could go to law school and pay a lot of money to have someone try to tell you to do what we're doing here. the nice thing is this is something I would be doing just to further my education, and I really appreciate that there's other people here to share this journey with me, because we will all gain from this together, and that makes us as a country stronger, because I truly believe that this common law is the greatest strength of our country. All right, let's continue here. And now we have the use of mails in the furtherance of a scheme to artifice or defraud, or to obtain money or property by means of false or fraudulent pretenses, representations, or promises is prohibited. Do you read this? This is very broad, but it touches on many, many things that we may see going through these mail transmissions. Let's read this again. The use of mails in furtherance. What does furtherance mean in a context of law? Oops. Let's see what it really means in a context of law. Give me just one moment here. Oh. Let's see, just a moment here. Sometimes it takes a while to find J, no, B, F, E, Well, that's awful strange. Well, let's just start from here and we'll find it, because I don't think it's listed specifically, but maybe it's under further itself. I've seen the words in Black's Law, but no, we're not going to find it like that either. Okay, so probably requires no further definition than the colloquial. But I want to make sure of that, because it's very easy to, hang on. It's very easy to misinterpret words if they're being used in a different way than you're familiar with. But if there is no other definition within law, within statute, within the rules you're interpreting, then your basic colloquial definition can stand. Let's continue. All right, so the use of the mails in furtherance of a scheme or artifice to defraud or to obtain money or property by means of false or fraudulent pretenses. So you're making pretenses that are based on false truths or fraudulent fact or fraudulent information, right? Representations. So misrepresentations. You say you're one person when you're another. Okay, so let's break this down. It's false or fraudulent pretenses, representations, or promises. Those are prohibited with the use of mail to further that scheme or artifice. The purpose of this statute, generally referred to as the mail fraud statute, which is lowercase, is to prevent the Postal Service from being used to carry out fraudulent schemes. You get that? The purpose of the statute, the purpose of it, generally referred to as the mail fraud statute, which we're going to look into further, is to prevent, the purpose of this is to prevent the Postal Service from being used to carry out fraudulent schemes. The mail fraud statute had its origin in the desire to protect individual property rights. And any benefit that the government derives from the statute must be limited to the government's interest as a property holder. Now that's very interesting too. So if there's a fraud to defraud the government, then the government would have a stake in this matter. But it seems that it was designed, the mail fraud statute, to protect individual property rights, and that the government, any benefit it gets from the statute, is limited to its interest as a property holder. So I guess any forfeiture through mail fraud cannot benefit the government, it seems, from the way this is written here. And of course, we have footnote 3 for further research here. The elements of wire fraud directly parallel those of mail fraud statute, but require the use of an interstate telephone call or electronic communication made in the furtherance of the scheme. Okay? Mail fraud and wire fraud are very similar. They're directly parallel. The difference is that the wire fraud will require the use of an interstate telephone call between the states, or interstate telephone call or electronic communication. So it's an interstate electronic communication or an interstate telephone call. Those are the two things made in furtherance of the scheme. So anytime you use a telephone call or an electronic communication across state lines in the furtherance of a scheme, it falls into this wire fraud statute, which is directly parallel to the mail fraud. So we should find similarities here. Thus, the standards applicable to mail fraud and wire fraud are the same. The standards. You get this? The standards. One and the same. We hear a lot about wire fraud, but rarely do you hear as much about the mail fraud and the mail fraud statute. So why? Is this not important news? I believe it is, and that's, I believe, why we're all here right now. Okay, so in ventilation, every breath. Right. Unfortunately, the breath of the artifice is a scheme intended to defraud people, right? So we can say it's bad breath. Let's continue. The mail fraud statute was extended to include the deprivation of the intangible right of honest services. That's pretty deep there. It was extended to include the deprivation of the intangible right of honest services. Have you heard about this? This intangible right of honest services. Intangible, right? This is something that's not existing in the physical world. So it's a right of honest service, deprivation of it. And as the mail fraud statute was extended to include this, the Supreme Court has held that this statute is not unconstitutionally vague when it is interpreted as being limited to schemes involving bribery and kickbacks. Number 6. So it seems like it's not unconstitutionally vague. So any amounts of vagueness to the statute would not be unconstitutional. It would be left with intention for further interpretation based on the subject matter at hand. All right, now we get to the good stuff, the observation. The right to correct records. Yes. So this, you see how it is? So when you say, I have a right to have records correct, first we got to look to why are they not correct? They're not correct because someone or mail fraud was used to deprive my intangible right of honest services, right? And honest services, it means part of that is having a correct record. So we could get to footnote 5 for further research, and 6 too. But let's get back to our observation here. Good point there, word wizard. Observation. The federal statute prohibiting mail fraud does not require some sort of interstate connection for its constitutional validity, since it is based on the Postal Power Clause, which gives the federal government the power to deliver mail intrastate. So interstate is between states. Intrastate is within the state. So the federal government gives a power to deliver mail intrastate as well to the Postal Service. Additionally, private and commercial interstate carriers which carry mailings between and among states and counties, are instrumentalities of interstate commerce subject to regulation under the Commerce Clause of the Federal Constitution, notwithstanding the fact that they also deliver mailings intrastate. Thus, here we go. The application of the mail fraud statute to intrastate mailings sent or delivered by such private or commercial interstate carriers is a permissible exercise of Congress's power. As a result, intrastate mailings are sufficient to satisfy the mail fraud statute, as a jurisdictional basis of the statute is grounded in the postal power and necessarily encompasses all items passing through the United States mails. However, the mail fraud statute only applies domestically. Very, very powerful stuff here, because when you look at it this way, it doesn't matter if you're, let's say you're being damaged by an action of what you perceive or allege as mail fraud. Usually, an affirmative defense stat or something would be such that, it doesn't apply because, they were within the state, or the postal power clause doesn't apply because of this or because of that. This would be a typical response, which would not be valid. How would you shoot it down? You would use this right here, this observation here. And you could actually use this type of wording, it's the interstate mailings are sufficient to satisfy the mail fraud statute, as jurisdictional basis of this statute is grounded by the postal power and necessarily encompasses all items passing through United States mails. And then you give them this footnote of this case law here that shows that, yes, there's someone else that is has maybe higher wisdom of justice that agrees with this interpretation as well. And I can guarantee you the other side probably doesn't have something as airtight and as well agreed upon. Remember, what we consider objectiveness is what many others pretty much agree on, almost by consensus. Subjective is that what's inside. Objective is what's out there. You want to try to argue objective realities, and the subjective persuasions are best left to the losing side. All right, let's continue. Let's see what we got here on the chat. Requirements in this is not what we're looking at here. Now, if you look at like the Code of Federal Regulations, will have more specifics. What we're looking at here is how the law treats the powers in the jurisdictions of the Postal Service. How can we see where it can be used lawfully and where people can be harmed when it's used unlawfully, and the proper way to seek remedy and to protect yourself from erroneous accusations and allegations. Let's see. Thus, the Franklin privilege evidenced by the ink stamp shows domestic. So again, these are details that were referred to here to the actual Code of Federal Regulations and the Postal Power Clause and such that will have the details of how and what things should be done. And what I like to do right here is actually look at where, when things end up with the courts, how are we going to articulate how things have gone wrong or right or should have gone, and the way that the law can prescribe a remedy to make things correct again. So this is where, usually when there's some type of dispute, is where these types of interpretations of common law come in. Because remember, the Postal Service is part of the fabric of our nation. It's constitutionally, woven into our laws. And abuses of things such as that can be very easily done if left unchecked. So there have to be ways to protect some of these services that the government is inherently providing to us. If you recall, the purpose of the Postal Service is to ensure a free press. That no matter what you wanted to publish, the Postal Service had to deliver it. And they couldn't violate your Fourth Amendment right by searches and seizures unlawfully either. And a bad letter taped to my door yesterday. I'm an illegal kicking. Oh, yeah, for sure. Oh, okay. So, again, when they do schemes like this, taped up onto your door, there's also sections in this. Again, this is a huge volume here of Postal Service. I think it actually probably runs over several bindings. And what this will cover is every lawful and legal aspect of the Postal Service. And what we're focusing on today is specifically mail fraud. And these statutes may apply to what happened to you, depending on that carrier that delivered that mail. Was it a non-deliverable mail, which is in here too, and laws that reference that and actually identify whether they did do a misstep in their legal actions. So let's find out. If they taped something on your door that really had an ink stamp on it, as Word Wizard said, then they might be in some trouble. If it's in an envelope and it's stamped and it has all this stuff on it, yet they taped it to your door, that could be an issue that falls into these statutes. So let's continue here. Let me keep in mind this stuff here, when we are getting it to the end here with these observations, this is what you're going to actually, the writings here can actually appear in your pleadings and your motions, because this is very clear, concise, and pretty much written almost in prose that any common person could understand, and certainly a judge could. So this is the type of argument that wins. Let's continue here. The mail fraud statute does not constitute an impermissible intrusion into state affairs in violation of the 10th Amendment to the federal Constitution. Impermissible intrusion into state affairs. So this is a little bit different. I don't think we're working on the state affairs end of it. Each use of the mails in furtherance of a fraudulent scheme is a separate violation of the statute. This is beautiful. This is the part of the things that I just love about American jurisprudence. It's full of Easter eggs and little treasures and things to find within it. And we have the reference here, of course. See, you can't just say these things without citing where it came from. And this is going to be a case holding probably and such, where you add this to your motions or your answers, your pleadings and such. This puts some serious teeth to your arguments that are almost impossible for them to rebut. So if you're getting repeated mailings, each use of the mails in furtherance of a fraudulent scheme is a separate violation of the statute. So each mailing can rack it up as far as violations go. On it then, you haven't missed too much. We go through this slowly, and we're looking through words too. And we're just going over the observation of the first part here of the federal statute prohibiting mail fraud does not require some sort of interstate connection for its constitutional validity, since it is based on the Postal Power Clause, which gives the federal government the power to deliver mail intrastate. So any type of mailing, even if it's within the state or between the states, would be covered under this the federal statute prohibiting mail fraud. Electronic communications for the wire fraud required to go interstate, between states. But mailing could be even within the state, and it would constitute mail fraud. And then the standards are very, very similar, I guess the same really, for the application. It says here, notwithstanding the fact that they also deliver mailings intrastate. Thus, the application of the mail fraud statute to intrastate mailings sent or delivered by such private or commercial interstate carriers. I'm sorry, that's the wrong one. Instrumentalities. Okay, so yeah. If it's interstate, intrastate, if it's done by the mail, it constitutes a mail fraud. And we said here that each use of the mail fraud is a furtherance in a fraudulent scheme, is a separate violation of the statute. So here we go. An observation. An implied private right of action cannot be maintained under the federal mail fraud statute. So this is something that some smart esquire might try to rebut if you're making an allegation that you've been harmed by mail fraud. They might say, well, you can't do this or that because there's an implied right of action and it can't be maintained under the federal mail fraud statute. And the implied private right of action seems like it's going to be a rebuttal that can't be maintained. And we'd have to look into footnote 14 to get more details on that. But that's why this observation is here. None of these observations they put in American jurisprudence should be overlooked because there's a lot that goes into this. This is trying to sum up everything that we previously read. And that's why they put them here. Very important. And the box just to make sure you don't miss it. So let's look at some of these here. I know we were looking at footnote 13 and 14. And was there another one we need to see? Here's the one on at them. I was saying the standards applicable to mail fraud and wire fraud are the same. The elements of wire fraud directly parallel those of mail fraud statute, but require the use of an interstate telephone call or interstate electronic communication made in furtherance of the scheme. That's the only difference. So other than that, the standards applicable to mail fraud and wire fraud are the same, and that's 4. So let's look at this here. We have footnote 4, which is this U.S. versus Briscoe in that 7th Circuit, 1995. Where's the 7th Circuit? Okay, and then we also have, let's see, as to the honest services mail fraud statute, also here is this one here. USCA 13 case section 1346, 18 USCA section 1341. Let's see, therefore, Supreme Court case striking gun-free school zones as unconstitutional was inapplicable since it was based on Commerce Clause. Wow. Strange things to come up with mail fraud in here, huh? But 13 and 14 are the ones we were looking at here. So we had this is 1986. And that's the 9th Circuit, U.S. versus Vaughn. And we also had the Foley versus the Plumbers and Steamfitters Local 149, and that was in 2000. So mail fraud involving them, huh? Pipe fitters. So there's quite a few things to look into here. So that's the private right. So, oh, I get it. Okay, so that's with the unions. But the 13 here is a great one because 13 is going to show that each individual mailing constitutes another count of mail fraud. So this is 1986. This is long held then. Great, 9th Circuit. Batters versus U.S. All right, let's continue and let me see if there's any questions here. So Word Wizard saying something here, and as I said, this is just a general review of this. I'm not a legal expert or law expert at all. I'm just reviewing this along with you guys and trying to take this journey of studying and trying to understand American jurisprudence better and common law. So that being said, I believe that what Word Wizard is saying in the chat here is it could be very accurate. And again, each time it's sent in the mail, something that's furthering any kind of artifice, a scheme to defraud, that's a count of mail fraud. So they can really rack up the counts. Let's continue here. So now we're on matter in furtherance or scheme of or artifice to defraud, the definitions and construction of terms. This is beautiful here, what we're getting to. Let's see here. The fraud requirement for a finding of mail fraud is construed more broadly than common law fraud. The fraud requirement for a finding of mail fraud is construed more broadly. So that means it should be easier to meet the requirements for a finding of mail fraud than just a common law fraud. A scheme or artifice to defraud includes anything designed to defraud by representations as to the past or present, or by suggestions and promises as to the future. The applicable standard is a reflection of moral uprightness, fundamental honesty, fair play, and right dealing in the general and business life of members of society. Wow. So what is an artifice? What is the applicable standard? Right? You could say it's anything designed to defraud by representations as the past, present. Okay, the applicable standard is a reflection. Think of this. This is very deep here, because what is a scam? What is an artifice? We define it in Black's Law. There's dictionary definitions, but when we're looking at it in the applicable standard of this, in this law, now this is what matters. This definition. The definition of a scheme or artifice to defraud includes anything that is a reflection or going against this, right? This is the standard. If you're violating the reflection of moral uprightness, right? It doesn't have a reflection of moral uprightness. It's probably a scheme or artifice to defraud. Does that have fundamental honesty? Now remember, just the fact it has fundamental dishonesty doesn't mean you're being defrauded unless you're using that dishonesty to cause you loss, injury, or harm, right? Fair play, are they playing fair? Is it a reflection of fair play? Is it a reflection of right dealing in the general business life of members of society? So if you're just out there minding your own business, making commerce perhaps, generating some type of fiat currency for your life, right? You're just a general business of life, right? The business life of members of society. The members are the people that, remember, of members of society is really the people and the institutions that function within the society, okay? So this is very broad and far-reaching. As we can see, the fraud requirement for finding a mail fraud is construed more broadly than common law fraud, and it's due to the statutory definitions that we're going into here. This is footnote 2, and let's see what footnote 2 is, because I believe it is. No, it's okay. It's okay. 1911. Wow. Common law, guys. That's common law. And the problem is these great common law ideas like, right dealing in the general in business life of members of society coming from 1911. It harkens back to a time when this common law was the very strength of our nation. And now with these liberal interpretations by these current judges, we're seeing a degradation of that strength, the very strength of our country. Let's continue. However, the federal mail fraud statute that relates to honest services criminalizes only schemes to defraud that involve bribes or kickbacks. So the federal mail fraud statute relating to honest services, right? And that was over here. We had the applicable standard. This is your checklist, right? Is it morally upright? Is it fundamentally honest? Fair play? Right dealing in the general and business life of members of society. We said honest services. That comes down to fundamental honesty is one of the checks. So when it comes to that particular check, it's only criminalized for schemes that to defraud that are involving bribes or kickbacks. So we need to figure out what those are. We'll come to that, I'm sure. Again, bribery in itself is a very complex way of law to interpret. There's two people for a bribe to commence. There's one that solicits a bribe and one that pays the bribe. So are they both convicted under the same law? Are there two separate laws? Do you have to give different standards for each of those parties to be brought to suit? Are they both one harmed, one not? I mean, how does that work, right? But that's where the cases where common law come in very good for this, and we're going to get into this deeper because it opens up more questions than answers at this point. Use congressional franking privilege to kick back mail. Yeah, okay, good thing I did. Interesting stuff about this, and I think it's very important for people to understand. I've just been lucky enough to not put extra information whenever I'm answering the court. And I've come to find that there is situations where, because I didn't include my mailing address on my answers to the court, I was able to retain my challenges to personal jurisdiction and win. I didn't realize I had that win done so well simply because I had omitted my address. Had I put my mailing address in there, I would have lost the ability to challenge that personal jurisdiction, and I may not have prevailed. So it's important for us to really understand the depth and the function of these laws. Because to take a cookbook approach to legal matters is not a winning strategy. Understanding the fundamental chemistry and the elements of how it all goes together and ends up with those, little rules and observations and tips. That's what we're trying to get at today. So let's continue here. The words to defraud have the common understanding of wronging one in his or her property rights by dishonest methods or schemes, and usually signify the deprivation of something by value of trick, deceit, chicane, or overreaching. These are great words here. Chicane deserves a better looking up, doesn't it? Beautiful. Let's see 298. All right. Oh, I missed it. There it is. Chicanery, trickery, deception, also termed chicane. So it's chicanery. That's a good one. Chicanerous. There are other variations. Chicanery. That's from the 17th century. Okay, let's continue. So, by trick, deceit, chicane, or chicanery, which is trickery or deception, right? Or overreaching, so abuses of powers. Yeah, so let's see here. Judicial, let me catch up with you here. Yeah, so all these U.S. code and sections are all also in the cases. All will be listed here too that you're mentioning here. But I just want to get into the summaries and such in here today. And of course, I encourage everyone to go and look at these case laws as that are being posted right here in chat. So this is a great reference for everyone. Thanks for putting that in there, Word Wizard. And these are the ones you need to read up on all this stuff. You need to have a copy of the U.S. Code anyways. But these are all the ways that we're going to apply what we're speaking of here. And this is the laws. This is the way that throughout the courts they've ruled and decided on. So we're getting a little bit of the why of the what here, and the statutes that are mentioned here are more of the what of the why. So let's see here. Yeah, there's some great forms in here. So thanks a lot for posting this, Word Wizard. I'm going to try to make sure this chat stays up for future reference, so you guys can go in there and look where these the U.S. code is here that he's referencing here. Let's see here. What else we got in here? The common law is an implication of the Plain Writing Act. Yes. So, well, Word Wizard's right on here. You totally defeat them with their own stuff. Again, though, it's not just having the stuff. The stuff has to become facts and evidence before the court will recognize it and put it into record. And what I want to do here is to really demonstrate the nuts and bolts of putting what we're saying here, all this stuff, as facts and have it entered as evidence into the court record so the court can move in our favor and we can prevail and have a remedy assigned. Let's continue. The federal mail fraud statute should be interpreted broadly insofar as property rights are concerned. This is also extremely important because you're talking about property rights. If someone's out there to say they're going to do bad things to you and take away your money or your property by the mail, that's mail fraud. If they're doing it through deceit, chicanery, overreach, meaning that maybe they could be issuing you out debt notices, but they're overreaching their authority by some kind of trick with you, and they're jeopardizing your property rights. They're concerned right now. This is a mail fraud situation by what I would assume. So let's continue here. The supplement here. We have fraud under the mail fraud and wire fraud statutes may be found from a series of isolated acts. And here we go with the U.S. code again. Oh no, this is U.S. U.S. court. And then we have this district case here. So let's see. Okay, no DDC. All right, so we have U.S. versus Bishop, 1987. Let me see, where are these footnotes? Well, number one is construed more broadly than common law fraud. That's 1987. And this 1911 case is great. So let's look at this one again. This is the one where includes anything designed to defraud by representations as to the past or present, or by suggestions and promises as to the future. If you don't do this, we're going to do bad things to you. That could be considered a mail fraud. They're going to defraud you of your property. This is my favorite one here, though, is the number 3. And that's 1986, 1984, and then yeah, okay. So that's I mean, it's old, but not that old. All right, any other questions on that section? All right, I can guarantee you that, considering what I've understood is they don't even teach this in law school anymore. If you're up against any kind of new Esquire, you might just have a little bit of an advantage by knowing this. Matter in furtherance of scheme or artifice to defraud. Use of false or fictitious name. This is good. I love this part here. Persons who, for the purpose of conducting, promoting, or carrying on by means of the Postal Service, any scheme or device. What is a device, guys? In law, it's not that little thing you hold there that you're watching this on right now. Because we could look at a lot of different kinds of etymology of it, but I'd like to see a good definition in law, which is hard to find. Here we go. Let's see. Wow. But here's another good one, though. This is, hang on. Let's see, 585 and wow. $545. Okay, so I want to look at this first. I'll just write something down here real quick so I don't forget the other one. But we have two good words here. Okay, so we want to see 5. Let's go to this first. The word we want to see is device. This is under patents. A mechanical invention, that's not the definition we want. 2, a scheme to trick or deceive. A stratagem or artifice. Remember what an artifice is, scheme to deceive. As in the law relating to fraud. That's a device. Did you know that? So in patent law, it's a mechanical invention. But in fraud, a device is a scheme or trick to deceive. A stratagem or artifice, as in the law relating to fraud. Incredible. Now, look at this one too. This is a really nice word here. And this is what I love about when you're doing this stuff, it takes forever to read a few pages in AmJur because you have to go through the definitions. Dolus, Latin, device, artifice, Roman and civil law. Fraud or deceit, conduct intended to deceive someone. Bad faith, the dolus. Although there may be dolus without fraud, fraud always includes dolus. culpa, causes, intentional aggression, willful injury, especially to another's property, also termed dolus malus, fraus. In the 12th century, the resuscitated Roman law introduced some new ideas. Men began to contrast, as Janville does, civil with criminal causes, to speak of dolus and culpa in cases, and to lay stress on the physical element in crime. The physical element in crime. Dolus. This is new ideas in the 12th century, the resuscitated Roman law. Frederick Pollock and Frederick W. Maitland, History of English Law Before the Time of Edward. Although the word malitia is not unknown to the Roman lawyers, the usual and technical name for wrongful intent is dolus, more specifically dolus malus. Dolus and culpa are two forms of mens rea. In a narrower case, however, dolus includes merely that particular variety of wrongful intent which we term fraud. That is to say, the intent to deceive. You get this here? Fraud is an intent to deceive, but we're concerned with the physical element of the crime in dolus. There's a physical element, and there's also an intent to deceive. From this limited sense, it was extended to cover all forms of willful wrongdoing. You get that? Both intent and physical. It's fraud. That's what we call fraud. But dolus is a type of fraud that involves the property, especially another's property. You get it? And it's an intentional aggression and a willful injury. So dolus is more than just fraud. Fraud could just be out because they're trying to enrich themselves and they're doing it by breaking laws, but an intentional aggression and willful injury, especially to another's property, is clearly a dolus. So let's continue on this a little bit more. Are we all still there? Because I want to make sure I'm not stalling on the chat here and I keep everyone's questions answered. I'm going to be bringing chat on the screen next one too. I'm just figuring out a way to do that without having a third party intervene with the streaming. Okay, so the intent to deceive. So fraud is the broader one. It's particularly a variety of wrongful intent, which we term fraud. So that's, in a narrower sense, however, dolus includes merely that particular variety. That's, of course, including another's property and the willful injury. From this limited sense, okay, the English term fraud has never received an equally wide extension. Interesting. So we have good deceit. Look at this, dolus bonus. Shrewdness or justifiable deceit, as when a person lies to an attacker to prevent an assault. Dolus bonus does not produce any legal consequences. So, interesting, a good deceit. So a shrewdness or justifiable deceit, as when a person lies to an attacker to prevent an assault, a dolus bonus. Now, this is something that's probably worth a little bit further investigation, but I digress, so let's get back. The dolus bonus seems like that if you were attacked by someone that was misrepresenting themselves, then you could also misrepresent yourself as a justifiable deceit to protect yourself from an unlawful attack. At least that's how I interpret that word. And by making a affirmative defense of the dolus bonus, then there's no legal consequences of that. Interesting. And you could argue that, probably based on, let's see, let me look at that case law. You know, the older versions of Black's Law would have the case law or something here that would, for this dolus bonus, that would actually help you cite it. But that's just neither here nor there. I have older versions too, but that's, again, I'm digressing. Let's continue here. So, persons who, for the purpose of conducting, promoting, or carrying on by means of the Postal Service, any scheme to devise for fraudulent purposes, use or assume, or request to be addressed by, look at this, guys, any fictitious, false, or assumed title, name, or address or name other than their own proper names. You get this? Or take or receive from any post office or other depository of mail matter such fictitious, false, or assumed title, name, or address by any other than their own proper names are liable to criminal prosecution. Word wizard, I hope you're listening on that, because that applies to directly what you were saying earlier in the chat. Employment of an alias can also evidence fraudulent activity under the mail fraud statute. So this is heavy. That's number 1, and that's 18 U.S.C. section 13. You get that one in here, word wizard? Almost, you're on the 17s. Okay, so there you go. When people are using fake or fictitious names, false, anything other than their own proper names, are committing mail fraud. Then, if you receive any post office or mail matter such fictitious, false, or assumed name, so if you pick up mail that's addressed to a fictitious name that's not you, you're also liable to criminal prosecution. So that's a good time to return that mail if it's not addressed to your proper name. That's not for you, is it? Or address. So any of these, doesn't have to be and. It says or. And employment of that alias can also evidence fraudulent activity under the mail fraud statute. So if someone's not using their proper name and they're sending you threatening mails, that could be considered mail fraud. The elements of mail fraud generally. If you recall, the elements or the standards of mail fraud and wire fraud are going to be parallel. The elements of mail fraud are going to be what varies. So let's find out here. This is great because we have the treaty and practice aids here. Federal procedure. You got this. Prosecution of postal offenses, mail fraud. Great stuff. Yep. So let's continue on here. Again, I could go on for a week on separate topics within this Postal Service, American jurisprudence, because, again, the Postal Service is something that's woven into the fabric of our nation since its inception. And the case laws are basically date right back to the forming of the country. So it's a good thing to study this in depth, and I like just to take it in these simple chunks that we can manage in these sessions like this. All right, let's continue. The essential elements of the offense of using mails in the furtherance of a scheme or artifice to defraud are: 1. A scheme devised or intended to be devised to defraud or obtain money or property by means of false pretenses. Number 1 element. Is it a scheme devised? These are your checklists. We only have 3 here, right? So this is all it takes. If you could be certain about all 3 of these, you've got the essential elements for a mail fraud case, right? So we have the placing or causing to be placed of any letter or other mail matter in any post office of the United States. So it has to go through the Postal Service. And again, that would be evidenced by the ink stamp, as El Perro was mentioning there. For the purposes of executing or attempting to execute the scheme, materiality of the misrepresentation is also an element of the offense. So for the purpose of executing or attempting to execute the scheme, right, the materiality of the misrepresentation is also an element for the offense. Another formulation for the requirements or the elements, requisite elements is 1. Here's another formulation. So this is one formulation. The thing is, when you're deciding how to make your pleadings, you're going to have to pick a formulation to start with and stick with it. You don't want to go from one to the next because there'll be holes in your case and they'll get broken down. So you first pick, like we said here, a formulation for your case strategy here. And these are essential elements for one formulation, these three here. Oops, come on. These three here are one formulation. And then there's another formulation. Let's look at this formulation. 1. Devising or attempting to devise a scheme or artifice to defraud. Okay, I'm just reading here, alias of Keith Orlin. It said proper name. We could look into further things with proper name when it comes to these things, which is going to be great. Man, I really wish I had my my chat thing going. You know, let me try something really quick, if you don't mind. Let's see if I can pull that chat up. I was in the middle of doing some coding, and I didn't really finish it, but I think I did. So let's see if I can throw this up real quick. Might be surprised. Yeah, it's just text we're throwing up here, right? And we'll call that the chat. And I need to get some CSS in here. Oh, man. No, I can't do it yet. What? Oh, chat log mode. Wait a second. No, that ain't gonna work, I don't think. Let me see here. Nope. No. All right, never mind. It was nice to try. We're not gonna do that yet. Sorry, guys. Get digressed like that, but I want to pull up some of these things here because we have some good things in chat, and it'd be nice to superimpose. Next session, I will. All right, so let's look at these elements here for our second formulation. Devising or attempting to devise a scheme or artifice to defraud. Knowing and willful participation in the scheme with a specific intent to defraud. So knowing, this is all it takes to have someone named in a suit for, I guess, a personal jurisdiction here. Knowing and willful participation in the scheme with the specific intent to defraud. Those three things: your knowing, willful participation, and the intent for this. Your willful, this intent to defraud. And the use of the United States mails in furtherance of that scheme. So let's see, under an alternate state of requirements, a mail fraud claim under both federal and state law. Wow. So both these had three elements here, both of these formulations. Let's see what the difference is. Oh, okay. All right, well, this would apply to specific situations, and you figure out which formulation would most apply, because there's too many scenarios to go through here. But I think you can see here there are going to be some distinctions. This one's looking at whether it's placing the mail is one of the elements here, right? And materiality in the misrepresentation, right, is one of the elements. Whereas here we have the use of the mails in furtherance instead of just the placing or causing to be placed, or any post office. So a little different way of going about it, depending on what evidence you have to present. And here we go. Under an alternate statement of requirements, a mail fraud claim under both federal and state laws. So if you want to get it under both federal and state law, here we go. You're going to have a representation or failure to disclose a material fact, a falsity, knowledge of the falsity, the intent to deceive, reliance, damage arising from the reliance, and the existence of a scheme that was reasonably calculated to deceive persons of ordinary prudence and comprehension. Beautiful. A conviction for honest services. Mail fraud does not require proof of the violation of state law, given that the duty of honest services owed by government officials derives from their fiduciary duties at common law as well as from statute. And that's footnote 5. 2001, U.S. versus Sawyer, First Circuit. Nice. So this is really important stuff we're getting at here. Now, this is when you're going under state and federal law. So it's pretty simple. If you really want to take it to that level, if you have a fraud case that's federal, and it could also be a state, because it's probably intrastate, right? The mailing you're within your state, you'd be able to get both under a federal law and state law, perhaps. And if you are going to go into the state law, it's just great to know this, because the existence of a scheme, right? Once you've reached this element, right, the conviction for honest services mail does not require proof of the violation of state law. You see that? Given the duty of honest services owed by the government officials. The duty. Look at this. This is where this case law, you can refer to this for various reasons here. The duty of honest services owed by government officials. It derives from their fiduciary duties at common law as well as from statute. So this is going to be an important case for a lot of things. Federal mail and wire fraud claims reach false promises and misrepresentations as to the future, as well as other frauds involving money or property. Yeah, Wizard, well, I'm going to get this, we'll get this thing set up so it's even better than StreamYard. I'm very much an open source kind of guy, and I like to do my own coding because I don't trust a lot of third-party intervention in things. And you know, we're already partnering with YouTube, our valuable corporate partner, and that's enough for me. Too many cooks in the kitchen will ruin the soup. All right. Again, federal mail and wire fraud claims reach false promises and misrepresentations as to the future, as well as other frauds involving money or property. Beautiful. Reach false promises and misrepresentations as to the future, as well as other frauds involving money or property. So boy, once you get into mail fraud, a lot of things might just pop up. So let's think of the cumulative supplement. These things are great too. Cases. All right. The scheme to defraud element of mail and wire fraud under Racketeer, Influence, and Corruption Organizations Act, the RICO Act. Racketeer, Influenced, and Corrupt Organizations Act. It's treated like conspiracy in several respects. As a result, each member of the scheme does not need to make a separate misrepresentation. Nice. 1960. That's Section 1961. Okay, so that's in the USC 18. And then we had this case in 2020. That's, let's see, it's Juul Labs. Isn't that the one that makes those things for smokers, right? Marketing, sales practices, and products liability litigation. Ah, I get it. North Dakota. Is that what that is? Yeah, 2020. Or North Dakota, California. I'm sorry. That's California. Ah, okay. So this is recent, 2020, and it involves this company right here. So they must have been sending something to the mail. So I'd like to see this suit. This is probably a good suit. Yeah, so some of these laws and stuff can be considered unconstitutional that are implemented, Word Wizard, and that's why I always like to look back to the common law, because, you know, if they really are on unlawful footing, then they need to be called out, because there's a lot of codes and laws that ended up being struck down later. Let's continue. I shouldn't say a lot. There are some. A mailing can serve as a basis for mail fraud conviction, even if the fraud would have been successful had the mailing never occurred. But that mailing, even if dispensable, must at least have some tendency to facilitate execution of the fraud. So even if you're not directly defrauded by the mailing, if the mail had at least some tendency, lost it. Hang on. At least some tendency to defraud you, then that would be, all right, let's see what happened here. Give me just a moment, guys. Just had a little glitch go on here, because okay. There we go. And let me just do one more thing here so that doesn't happen again. Okay. Get back. All right. Studio mode. Back we go. All right. Shoot. Let me get back to where we were. Fictitious names. Elements. So those are a review here. And as we get to the scheme to defraud. So, yeah, so this is going to be a good section here. This might be a good place to pause it for the night. Let me just go back over to this one more time. So a mailing can serve as a basis for mail fraud conviction, even if the fraud would have been successful had the mailing never occurred. But that the mailing, even if dispensable, meaning it could be dispensed and thrown out of the whole scheme, it must at least have some tendency to facilitate execution of the fraud. So even if you saw it and it scared you and you threw it away, it still could be considered an element of mail fraud along with the rest of the scheme. All right. This is the individual requirements. Just seeing here, opinion modified as reliance as an element. So good notes here, the footnotes. But they're not elaborating on anything, so we'll just keep going here. All right, now we're on the scheme to defraud. All right, great. We got some people here. Let me just quickly look through here. Pattern racketeering includes at least 2 acts of racketeering activity. You know what? Hang on, let me try something. I think I can pull this up here easier. Yeah, there it is. Oh, what do you know? I wonder if I can... Participants? Really? Let's see if I can bring them in. It doesn't work like that. Okay. All right, so the pattern of racketeering... I'm just surprised I can't bring this into the screen here. I bet there is a way. I'm going to find a way someday. All right. Documentary material includes any book, paper, document, record, yes. So we get into records and record keepings and such, also in American jurisprudence. And that's where we get into the hard facts. And as this Banker Lies here says, all this is good because when you get in front of a judge, you best have balls of steel. The best thing about this stuff is hopefully we never have to be in front of the judge if we know this stuff, because we could do all our pleadings on paper, all our motions and actions through the clerk, and very little time we have to actually be in front of a judge, so to speak, because the cases should be airtight as it is. But if you do have to be in front of one, I could say that you'd be well better prepared than the other side. All right, so let's go on the scheme to defraud. So mail fraud requires the existence of a scheme that was reasonably calculated to deceive persons of ordinary prudence and comprehension. all aspects of the scheme need not be illegal when considered separately. Rather, it is sufficient that the scheme as a whole involves fraudulent conduct. So all aspects do not need to be illegal. There could be some aspects that are legal within the scheme. However, when considered separately, rather, it is sufficient that the scheme as a whole involves fraudulent conduct. So that's it. Those who act with reckless indifference to whether a representation is true or false are deemed to know the falsity. Those who act with reckless indifference to whether a representation is true or false. You get this? Act with reckless indifference to whether something is true or false. A representation. Not a presentation, a representation. So they're not looking at firsthand, they're looking at a representation. Is true or false. They're not going to care. They're going to be indifferent. Then they're deemed to know the falsity. Beautiful. A scheme to defraud need not succeed to violate the mail fraud statute. Important. You don't have to lose money to be defrauded or property. And proof that an intended victim was actually defrauded is not required to establish guilt under the statute. Good. However, a scheme to defraud does require some degree of planning by the perpetrator and is essential that the evidence show the defendant entertained, allowed to entertained an intent to defraud. So that's another good word to look up there, is entertained in the legal definitions. Because I have a feeling it means something a little bit different than in school. 639. There we go. Entertain. 15th century, to bear in mind or consider, especially to give judicial consideration to entertain, give judicial consideration to. The court then entertained motions for continuance. 2, to amuse or please. 3, to receive a person as a guest or provide hospitality to a person. Parliamentary law, to recognize and state a motion. To receive and take into consideration. The chair will entertain the motion. Got it. So in this case, we're looking at this, to bear in mind, to consider, especially to give judicial consideration to. Okay, so we now know how we're using entertain, to give judicial consideration to. Okay, let's get back. Going. Why isn't it switching back? We're online. There it goes. All right. Bit of a delay there. Okay, however, a scheme to defraud does require some degree of planning by the perpetrator and is essential that the evidence show the defendant entertained an intent to defraud. Let it enter his mind. Right? Consider. Bear in mind, to consider. That's what he was doing, right? Or she. They considered an intent to defraud. Although fraud must be pled with particularity, meaning particular, like a particle, right? Individual things. You can't just group it together. It needs to be pled with particularity. It is not required that the temporal, time-wise, or geographic location patterns of each mailing made in furtherance of a mail fraud scheme be stated with particularity. So before we continue here, although it must be pled with particularity, this happened at this time in this place with this subject matter, it's not required that this that the geographical and temporal particulars of each mailing made in furtherance of the fraud scheme be stated with particularity. So in other words, you could say he sent me 20 mailings between this and that. I don't have to say necessarily, it's not required I give the exact date and areas or such, but only that the plaintiff delineate with adequate particularity in the body of the complaint the specific circumstances constituting the overall fraudulent scheme. Again, details are always great, but you're only required details in the pleading, the particularities, but the particularities are not necessarily required for each mailing that were made in furtherance of the mail fraud scheme. Okay, we're all still there? So under our cumulative supplement here, we have a good little thing here. It says, under the mail fraud statute, post-fraud accounting among the potential victims generally is not an essential step in a scheme to defraud because the perpetrators of fraud generally are indifferent to the fact of who bears the loss. An interesting here concept, right? Under the statute, the mail fraud statute, post-fraud accounting among potential victims generally is not an essential step in a scheme to defraud because the perpetrators of fraud generally are indifferent to the fact of who bears the loss. So I guess post-fraud accounting among the potential victims, going back to check and make sure about them, I guess, is in contrast, the perpetrator's receipt of the proceeds of the fraud is an essential step in a scheme to defraud because the success of the fraud depends on it. So the receipts of the proceeds of the fraud. Again, this brings about some confusion here because we read earlier that you don't need to necessarily be defrauded. Does not, let's see here. Yeah, proof that an intended victim was actually defrauded is not required to establish guilt under the statute. But then down here we read that receipt of the proceeds of the fraud is an essential step in the scheme to defraud because the success of the fraud depends on it. Now, whether they actually completed the fraud, but you still have to show that there were receipt of proceeds of the fraud, whatever that means, right, in the steps to the scheme to defraud because the success of the fraud depends on it. So this is interesting. This is 2021, so they're already splitting hairs on this. And this is 8th Circuit. All right, so here we go. Some more additional opinions. Young versus Wells Fargo. We've got some older laws there. I don't want to get too over time here, but we're hitting that hour and a half mark. I still have everyone with me here. Okay. It is not necessary that the mails be the essential or pivotal aspect of a scheme to defraud. It's not necessary that the mails be the essential or pivotal aspect of the scheme. They don't have to be essential. They just have to be, it is sufficient if it is the use of the mails be incident or related to an essential element of the scheme. That's it. As long as it's related or incident to an essential element of the scheme, then it would constitute scheme to defraud through mail fraud statute. The mailings must, however, be for the purpose of executing a scheme or artifice to defraud. The mail fraud statute is not applicable merely because the mails are used as a result of a fraudulent scheme. In other words, the nexus between the scheme and the mailings must be shown to invoke the statute. Thus, if a fraudulent scheme as conceived by the perpetrator has been fully executed, then any related mailing, even if it's sent to facilitate the concealment of the scheme, falls outside the mail fraud statute. Interesting, isn't it? The mailings must be for the purpose of executing a scheme or artifice to defraud. The mail fraud statute is not applicable merely because the mails are used as a result a fraudulent scheme. In other words, the nexus, the legal, where it meets the legal needs here, right, between the scheme and the mailings must be shown to invoke the statute. So we need to find some nexus between where it crosses, those mailings and the statutes meet. Thus, if a fraudulent scheme as conceived by the perpetrator has been fully executed, then any related mailing, even if sent to facilitate the concealment of the scheme, falls outside the mail fraud statute. So even if they do something to try to conceal the scheme, that can't be considered part of a mail fraud. If they scheme you totally outside or defraud you outside of the mail fraud statutes and then send you a mailing to try to conceal the scheme, that would not be considered a mail fraud because it didn't intend to get you to lose property or cause loss, injury, or harm. Okay, so the false or fraudulent representations themselves need not be transmitted by mail. Routine business mailings that are closely bound with the scheme will satisfy the element of mailing. Wow. Accordingly, the predicate transmissions for a claim of mail fraud do not have to be alleged as false or contain misrepresentations. Rather, they need only be in furtherance of a scheme to defraud. Remember this. And if such allegations are made, the complaint need not specify the precise nature of the misleading statements, but must still particularly describe the scheme and how the communications, although facially innocent, furthered that scheme. Interesting. So this is where we start splitting hairs in this stuff. Again, this applies to specific cases. You really need to thread it through this needle here because that's where if you're trying to admit something that's going to be struck down, it's wasting everybody's time and especially you because it's only going to hurt your case. And to try to defend yourself against something that can be shot down too. But as you see here, we spend a lot of time on very few pages here. And we've pulled out a lot of words that we haven't known, and maybe we did and we didn't know as well. But this is the kind of stuff that, when you hire someone as counsel, that they should be doing this or already have done this. And I could say this much, is I know very few Esquires that actually would sit here and do what we're doing here. So I salute everyone that's out here and doing this along with me. Again, this is a learning process for me as well, and I appreciate everyone coming on this journey and sharing it with me. Okay, so the scheme to defraud, the effect of legality of individual actions. Before we go on to this, I just want to get back to the words because I don't like to drift too far without getting full meanings of words for everyone here. And sometimes they're words I know or maybe other people don't. And I don't want to be pretentious and assume that everybody knows all these words or that I know words, but I want to get down here and make sure we're all on the same page, literally, and no word left behind. So let's get on to nexus, because that's a word that we see a lot in law, and it behooves us to really know what it means in the context of law. So let's find out. Okay, we have nexum and nexus. 17th century, a connection or link, often a causal one that causes, not casual, causal. Cigarette packages must inform consumers of the nexus between smoking and lung cancer, a connection or link. Comes from Roman law. In very early times, a debtor given in bondage to creditors until the debts have been paid. Nexum. Yes, that's the nexum here. Boy, that sounds bad. Nexum, in Roman law, a transaction or practice of early Roman law under which a debtor, upon failure to repay the debt, could be seized and held in bondage until the debt was repaid. This practice was allowed in very early Roman law. Yikes. And then we have the nexus test, 1975. Okay, this is the standard by which a private person's act is considered state action. Wow. and may give rise to liability for violating someone's constitutional rights if the conduct is so closely related to the government's conduct that the choice to undertake it may fairly be said to be on that of the state. Wow. While similar to the symbolic relationship test, the nexus test focuses on the particular act of complained of instead of on the overall relationship of the parties. So it focuses on a particular act complained of instead of on the overall relationship of the parties. Still, some courts use the terms and analyses interchangeably. So, wow, this is a whole nother thing to read up on. But good stuff here, the nexus test. All right, let's continue. Or I digress too far. Okay, let's continue here. So, regardless of how seemingly fair and honest a scheme may be, if its purpose is to defraud and the mails are used in furtherance of the scheme, it falls within the prescription of the mail fraud statute. It is not necessary that the scheme or artifice be in itself unlawful under state law, as in fraud at common law or by statute. See, it's not required that the scheme or artifice be itself unlawful. Conversely, merely because a scheme may violate state law does not exclude it from the proscriptions of the federal mail fraud statute. So you can get them both, is what this is saying here. Just because a scheme may violate state laws does not exclude it from the federal mail fraud statutes as well. Okay, so conversely, so the other side of that, it's not necessary the scheme or artifice itself be unlawful under state law as fraud at common law or by statute. See, so this is really working in favor for people that are being wronged by mail fraud. Mailings cannot be for the purpose of executing a fraud when they are made only in response to an imperative command of duty imposed by law, unless they are also false or fraudulent. So, mailings cannot be for the purpose of executing a fraud when they are made only in response to an imperative command of duty imposed by law. So if you're asking for someone to pay you something that they do owe you by law, then it can't be considered false, and it's not false or fraudulent. It's not considered a mail fraud. And the mailings done in furtherance of the scheme may also be innocent in themselves. So debt collectors for lawful debt. Essentially, the offense of mail fraud consists of the use of mails in executing or attempting to execute the scheme to defraud. It is not the scheme itself. See this? Essentially, the offense of mail fraud consists of the use of mails in executing or attempting to execute the scheme to defraud. It is not the scheme itself. Number 6. U.S. versus Blankenship, 1984. That material sent by mail is integral to the execution of scheme is sufficient. Just the fact that it's integral to the scheme is sufficient for mail fraud, not that the mailings itself constitute the mail fraud scheme. Interesting. And then schemes to defraud, relation to other laws. And I think at this point it's a good place to leave off for everyone, because now we're going to get a little lost in the weeds here where we start to overlap with other laws you may or may not be familiar with. And I just want to keep everyone on the same page here that we're leaving off on page. I can look on here too. I better look on mine because they get renumbered here. So that's page 260. Service fraud, and we're doing page 60, 260 is what I'm leaving off on my reference. All right, so is there any other questions we have in chat that we can answer here? Because we can get into this on the next time we go into it. I'm going to just page through here to show you what's upcoming. This is a huge document. We're actually towards the end of it here. False statements by defendant to victims that additional funds were necessary to cover impending health insurance premiums for a company in which investment originally had been made And if that company lost its insurance coverage, it would jeopardize then pending sale or material misrepresentations. Additional funds are necessary to cover impending health insurance premiums for a company in which investment originally had been made. Would jeopardize then pending sale. Okay. Supporting his wire fraud conviction. Even if defendant did not misrepresent value of stock purchased or minimize risks inherent in investment, the defendant falsely represented need for investor funds and use of those funds by indicating further investments from victims to protect their initial investments and expedite their return. Wow. So, anyways, we're getting ahead of ourselves, but that's the beauty of American jurisprudence is it's really hard to put down once you pick it up because it just keeps going. Causing use of mails. We get into some pretty detailed stuff here, but I want to leave it at that. Is there any other questions that we can bring up here in the chat? I just want to make sure that we're all doing well here to understand this concept of mail fraud. I think what we could do to sum it up is that mail fraud can be both a federal and state criminal offense. It doesn't require the mail fraud in and of itself to be the fraud scheme, but it has to be integral to the fraud scheme. And that the intrastate as well as interstate overlap of the Postal Service's duties have a lot of statewide implications, including those things of the fair and honest services by the government workers. So there's a lot of different aspects to mail fraud that have both federal and state implications. Personal property. We learned about the difference between a dolus and a straight fraud, whereas a dolus would involve that property and that willful intent. So we have a better, a more stricter, sharper term for fraud when it involves material or property damages. These are ways that it can also, we also found some elaborations on that word of dolus, the dolus bonus, meaning deceit for the good, in that you can't be criminally liable for a deceit to protect yourself from a wrongdoer. So there's some pretty interesting concepts that run very deep just from one topic here of mail fraud and postal service, that because we're looking at from the lens of American jurisprudence, we're enlightened to so many other deep principles of law that make this country so great, and the due process that affords us protections that these rules and principles are followed throughout the legal process here in this country, but only when we demand it and we know what to demand. And that is the genuine purpose of why I'm doing this for everyone, is to bring everyone up to the level that we respect the rights that others have sacrificed for us and aren't indifferent to these rights that separate us from pretty much the rest of the world. With that, I really want to appreciate everyone for attending, and I look forward to the next one. Any ideas for further presentations for American jurisprudence, I'm always open to suggestions. And I have second parts to work for both this one and for the administrative law, which we can get over to at another time if I don't see any other suggestions for topics. Other than that, endless topics with American jurisprudence. Great stuff. It really makes people have, I think, a better love and loyalty of their country when they know how to exercise laws to ensure that we're all getting our equal laws applied equally to protect our equal rights. And on that note, I would like to say thank you everyone for attending, and have a great day, good night, and peace out.